Number 128, People versus Poleun. Counsel, you don't want any rebuttal time?
No, Judge, thank you.
You don't want? What do you think?
No rebuttal, thank you.
No rebuttal. Go ahead,
No voice problem today.
That's okay.
I'd like to just address preservation first. It was not raised by the people in the appellate division. It was in the appellate division decision that the request to be present issue was not preserved. It's our position that that's a bit of a red herring, that it shouldn't even be an issue here. This defendant wrote 2 letters to the court. He indicated that he wanted to be heard. He wanted to participate in this hearing. Everyone seems to ignore that. The people's briefs, both in the appellate division here, Judge Murphy's decision, and in the appellate division decision, they ignore the fact that he was essentially pleading with the court, saying, I want to participate. I've got a lot to say. There's things.
But based on what he said, I understand you're starting with preservation, but what's involuntary about it? He says, I want to be there, but I can't. I'm worried about something. So listen, I've talked to my lawyer. I've talked to this one. I've talked to that one. He'll present the arguments, so I won't be there. And, why is that involuntary?
It's involuntary because of why. Because he says, if I'm transported now, they're going to bring me to Attica, from Great Meadow to Attica. If I go there again, I'm going to get beat up.
What should the judge have done?
He should have required the attorney to speak directly to the client and just comment again on what Judge Flippin.
Well, let's assume he talked to his client. What then?
Well, when the judge asked the defense counsel when he presented him with the waiver, he said, did you speak with your client? And he said, my office spoke with my client. The implication there is that he never spoke directly to his client.
Let's assume whatever you want to assume. What then? I mean, you say, okay, the defendant says, I'm not coming because I'm not going to Attica because I'm going to get beat up. What does the court then do?
I think then you're presented with a waiver that is based on duress, and it's involuntary by its very nature.
What do you then do?
So you direct the attorney, say, well, talk to your guy, adjourn for 2 weeks. This guy was.
What do you do after 2 weeks?
Hold the hearing. He was going to be released in a few weeks.
How would he hold the hearing? If the client doesn't come because he feels under duress, how would he hold the hearing?
He could have ordered him to come to the county jail. There had to be something he could at least look into it. He could adjourn for a week and look into it and say, is there something we can do?
Can they do that?
Didn't he suggest a webcam?
Pardon me?
Didn't he suggest a webcam?
The defendant himself suggested a webcam in a second letter to the judge.
Do you know if that was a real option?
I don't know if that was a real option in that court.
So if any defendant could then say, gee, I'd really like to be there, but the way that they transport us and everything, I don't want to be in this other facility. I think it's really dangerous there.
Well,
I've heard that they threaten people and beat people up and stuff. So then that imposes upon the court an obligation to hold a separate hearing or arrange for a webcam or some other. Is that all it takes? I mean, this isn't a case. I guess this isn't a case where the guy said, I was threatened that if I go to this hearing, okay, this is what's going to happen to me. To me, that might be a little bit different. But where do we draw the line?
He did say it had happened before. In the first letter, he said, I will get beat up as I had been before.
But is there any real way, any practical way to ascertain whether that is in fact, I mean, maybe he did get beat up, but maybe he got beaten up because he was in a different gang than the people there or something. I mean, I guess.
Certainly it's problematic in doing that, but he's in the custody of the state, and it's the state that wants to put these prohibitions on him and put this level 3 designation on him. And given in this case,
But appearance at the hearing is voluntary, is it not?
Appearance is always voluntary at these hearings.
Voluntary. So why can't the court rely on the representations by counsel and the written waiver? Perhaps he's changed his mind. Perhaps he feels comfortable now with his counsel representing him. He had obviously been in communication with counsel. Why can't the court rely on that? Don't you really have an ineffective assistance of counsel claim?
There very well may be an effective assistance of counsel claim here. Yes. And that's why I wanted to start with the preservation issue, because there was no way for this defendant to,
But why can't the court rely on counsel's representation?
if counsel had said, I spoke with my client, that would be a different situation, but he said, my office spoke with my client. And I think that implies that he didn't speak directly to him either about the waiver, the effect of that waiver, or about the issues that he was raising about the danger he faced if he was transported.
Well, again, assuming that's true, counsel, going back to Judge Piggott's question earlier, what would the court do? You said adjourn the hearing and have counsel speak to him,
I mean,
speak to his client?
these hearings are quick. I mean, I think it's 8 pages of transcript was the hearing here. A webcam is certainly not an unreasonable situation. A telephone call even, have the defendant on the telephone and do it with the stenographer there over speakerphone. I mean, it's 2015. We can do a lot of things like that. This guy, I mean, there's a lot of things that they were saying about him that are sketchy at best. There's a rape charge where the charges were actually dismissed, but the appellate division comments on that as one of these aggravating factors.
But the defendant have, and he wrote these 2 letters, could he have said, you know, I'd really like to come, but I'm afraid to come. My attorney's going to be there, my parents are going to be there, and here are the things, in his letter to the judge, here are the things that I think ought to be raised here. Could he have done that?
We all wish we had clients that could be articulate and think ahead like that, but he didn't do that.
But he did say his attorney would speak on those matters, and that his parents would be in the courtroom as well.
Right.
I don't know that he was suggesting they would speak on the matters, but he did expect that his lawyer would point out these inconsistencies or issues with the statute.
And I think if you look at that 8-page transcript, you don't see very much in there by way of refuting
Doesn't that get
these
to an effective
allegations.
assistance of counsel claim rather than that he was denied due process because he wasn't able to appear?
Possibly so, yeah.
Okay.
Thanks, sir.
Thanks, counsel. Counsel?
Thank you, Your Honor. Laura Bittner on behalf of the Niagara County District Attorney's Office. May it please the Court. The reason that none of these other avenues were suggested, such as a webcam or a phone call or an adjournment so that this attorney could speak with his client, is because defense counsel never requested that. Defense counsel had a waiver in front of him. Their office as a whole had spoken to that defendant and submitted that waiver and asked the court to take that waiver as a waiver of the defendant's appearance at that hearing and ask the hearing to proceed.
Could a webcam appearance have been affected here?
I appear in that court quite a bit. I've never seen it done. I don't know if it would have been possible or not. But again, it's something that was not requested here. This defendant felt comfortable after speaking with the public defender's office.
Well, he requested in his letter. I mean, how many times does he have to communicate, I'm afraid, I've gotten beat up before, I really want to be there, there's lots of problems with what the government is saying about me, maybe I can do it by, how many times does the incarcerated person have to present this to the court?
Well, he sent the initial 2 letters and then had an opportunity, as we see in the waiver, to speak with his attorney. And I think that what the court needs to rely on is this final waiver that shows that, you know, he knew the time, he knew the date, he knew that the hearing was going to proceed in his absence, and that he had spoken with his attorney. I think that if we had, you know, only the 2 letters to look at, I think we might have a very different scenario. But since we have a waiver of appearance here that seems to be knowing and voluntary in this case, I think that that's something that the court can rely on here.
So you would agree, though, that there are circumstances under which an allegation of coercion or threat or something of that nature might require some further action?
Absolutely. And had, after defense counsel, the public defender's office spoke with this defendant, thought that there was something that needed to be brought to the court's attention, my assumption would be that they would have done so. But as all parties involved in this seem to be comfortable with this waiver and for defense counsel to be proceeding, we don't have that scenario here.
Okay.
Thank you, Your Honor.
Thank you. Okay, thank you both. Appreciate it.